Hello, welcome to Lobus. We are going to see the topic rule against bias. Okay, so this is one of the principle of natural justice, and we have the principle of natural justice. One is rule against bias, one is audiologist partum, and reason decision. These are three principles of natural justice, and audiologist partum is discussed. Reason decision will be discussing. Now we are seeing rule against bias. In our previous videos also natural justice was discussed. By seeing that video you will have a good and fair idea about natural justice and the important cases, what is that, and how the judiciary or administrative authority applies natural justice. So we move on to our video. We'll see the rule against bias. As you are seeing in the diagram, we are seeing three principles of natural justice, and we are going to deal with rule against bias. Okay, so we move on to our video. So what is bias? When you hear the word itself, what comes to your mind? So you'll see, bias is inclination or prejudice for or against one person or group, especially in a way considered to be unfair. So bias is something unfair which is done, which is fairing another party. This is bias. Okay, anything which tends or may be regarded as tending to cause such a person to decide a case otherwise than an evidence must be held to be bias. When an adjudicating authority, administrative authority, or judges, when they did not see an evidences or when they have a particular things in their mind and in a favor they are doing in judgment, such things tend to be biased. Okay, so we move on. So absence of bias or rule against bias is based on three maxims. These are the important maxims of rule against bias. Okay, you need to know this and you need to write for your exams as well. So what is that? The first maxim is nemo debet esse judex in propria causa. So that is, no man shall be a judge in his own cause. This is the first principle of absence of bias or rule against bias. The second one is justice should not be done but manifestly and undoubtedly be seen to be done. This is the second maxim of bias, absence of bias. The third one is judges like Caesar's wife should be above suspicion. So these are the three important maxims of absence of bias and rule against bias. Okay, as we proceed further, we'll see what is this. Okay, so that you'll have a proper good idea. So we have four types of bias. One is pecuniary bias, personal bias, official bias, or judicial obstinacy. So official bias is also called bias of subject matter. These are the four types of bias which you are going to see. Okay. The first one is pecuniary bias. As the word suggests, pecuniary, you might have got a right thing that what is that, okay? Is a situation where a decision maker in an administrative process has a financial interest in the outcome of the decision. So pecuniary bias when you're seeing the decision maker has a particular interest in the outcome of the decision so that he'll have a benefit or financial interest. This is pecuniary bias. Okay. So the least pecuniary interest in the subject matter of the litigation will disqualify any person from acting as a judge. If any minute pecuniary interest is found when a judge is acting as a presiding officer, when a minute thing is found, a pecuniary interest is found, the judge should not be the judge should not be acting as a presiding officer in such cases where he has a pecuniary interest or he has a financial bias or he is somewhere related, in any way related. He should not be taking up such cases. He will not be dealing with such cases. So in order to prevent bias, it is done so. So this is explained in pecuniary bias. Okay, if an authority who has pecuniary interest in the subject matter of the dispute decide the case, the court will quash his decisions on the ground that authority has acted against the principle of natural justice. So as I mentioned, even if the judges or an authority, adjudicating authority or administrative authority, whoever concerned is having any least pecuniary interest, so it is violative of natural justice, and it will be seen that the decision is not proper, and there will be chance that the decision is disqualified, or it will be treated as quashed. The court can quash it. Okay, this is pecuniary bias. So hope we have understood. Hope we have a fair idea. So even if you have a least interest, or the adjudicating authority or judges have a least interest in a case, they will not be taking up the case such as. So in order to prevent bias, so this is an important thing which you are going to see. This is keep in mind. Okay. Boham's case is also called Dr. Boham's case. Okay. So what was that? Is Dr. Boham was a physician and was fined by Royal College of Physicians for practicing medicine without license. He didn't have license for practice, and this Royal College of Physicians, they fined him for practicing without license. And the college had the monopoly on the practice of medicine and was empowered to impose fines for violation and its regulations. And every kind of this right was given to royal colleges for any kind of, they could collect any kind of fines or impose fines if they find something illegal. Boham contested that this was unjust and argued that the fine was unjust and the statute was unreasonable. This was contention of Boham. So this is an important case in rule against bias. The decision was done by Sir Edward Coke, the Chief Justice of Court of Common Pleas. Coke ruled that while Parliament has authority to pass statutes, a statute that violates common law principles, in this case the rule that no man shall be judged of cause, should be deemed void and unenforceable. So the next case is J. Mohapatra and Company versus State of Orissa. The committee was set up by government for the selection of books for education institutions. And the members of the committee were authors themselves, okay, and whose books were to be considered for the selections. So you understand the scenario. A committee of government appointed a committee, and the members of the committee itself are authors, and their books are also there for the selection category. The committee selected the books of other members. So you're seeing a bias occurred there. Okay. The Supreme Court held that the possibility of bias could not be ruled out. The possibility of pecuniary bias was observed and was set aside. So there is an ant, and an ant is missing here. Sorry. So you understood the Mohabbat case? I hope so. So the committee was set up by the government and for the selection of books to the education institution. The authors were also there. Of numbers were all authors, and they were also in the selection list. So and they selected the books of the authors who were present. So there occurred pecuniary bias. They had some pecuniary interest in the subject matter, so that when their books are selected, they will have remuneration, right? So this was set aside by the Supreme Court, seeing the biases occurred. So this pecuniary bias. Hope you understood. Okay. The second one is personal bias. So a personal bias occur in a number of circumstances may give rise to personal bias. Okay. A judge may be a relative, friend, or business associate of a party. When a personal bias occurs, this is a situation we are seeing. Okay, in many situations, personal bias occurs, and when a judge is a relative, friend, or business associate to a party, there can be a personal bias occurring. Okay, when a judge is having a personal grudge or enmity or grievance or professional rivalry against the party to the suit, their bias can occur. Okay, this is the other situation. So, in view of this factor, there is likelihood that the judge may be biased towards one party or prejudiced towards the other. So when a person bias occurs, judges can, if a person bias is occurring, the judges may be biased towards one party or prejudiced towards another. If he is a friend, he will be biased towards that. So if you have any personal grudge, the decisions can have any problem. The judge is having a personal grudge or enmity against a party. So there can occur a kind of bias. So the decisions will not be proper. So this is things when a personal bias, the things are taken up. We are seeing, okay? That is a person who's a relative friend or enemy of disputing party is disqualified from acting as a judge. So, if a judge is having any sort of connection with a party to the suit, the judge is disqualified to be the presiding officer of that case. So that in order to prevent bias, so so the decisions will be fair, just, and accurate, and there will not be any kind of bias occurring. So this is personal bias. So we have seen A.K. Kripak was a student of India when we discussed in our natural justice video. This is very important cases in person bias also. When you're seeing the natural justice video, you will have a fair idea that how natural justice has been followed and how this pecuniary interest is seen in A.K. Kripak also. So what is that? In A.K. Kripak, the facts was that Nashing Bound was a candidate from in JNK, the state of Jammu and Kashmir, and he was in the selection of IFS. He was also a candidate for IFS, and he was in the selection board also. So there occurred dual role. He was acting in dual positions, even though he didn't give any kind of interviews or he didn't present himself for any test as well, but he was selected blindly. So there occurred bias. Since he was in the selection board, he was selected without giving any kind of interviews or exams. So this was discussed in A.K. Kripak Position of India. So in order to prevent bias, in order to the procedure to be fair and reasonable and accurate, the person should not have any sort of things related to the case, any connection with the case. Okay, so here we are saying A.K. Kripak versus Union of India. Another case is Cottle versus Cottle. This is the main case of which provides importance of impartiality. There was a matrimonial issue with the Cottle and his wife, and the presiding officer was wife's family's friend. So Cottle believed that though the case might have occurred, the occurrence of biases occurred. There was a person bias occurred favoring his wife. So even if you find a one person interest in the particular case, it will be had as void. So here in courtal cases, you will see importance of impartiality in administrative decision making. So when you have a particular interest in such a case, you should not be the presiding officer in such cases in order to prevent bias. So we move on. Official bias or bias of subject matter. What is that? Arise when a judge had a general interest in the subject matter of the case. When it occurs when a adjudicating authority, a judge has a general interest. So both, and you have seen official bias. You are seeing official bias and the subject matter bias. Subject matter bias occurs when person making the judgment is interested in the case subject matter either directly or indirectly. It can occur directly or indirectly. Any kind of interest if you have towards this case in the subject matter, this is official bias or subject matter bias. Okay. So this is important case in subject matter bias, that is Villapalli Nagareshwara Rao versus Andhra Pradesh State Road Transport Corporation. So here the Supreme Court quashed the decision of Andhra Pradesh government nationalizing road transport on the ground that the Secretary of the Transport Department was given a hearing, was interested in the subject matter, leading to subject matter bias. Secretary who initiated scheme and who heard objection were the same. So here the government's nationalization process of road transport was both the secretary who heard the case and initiated the scheme, both were the same. So here this official bias can occur. So this was a thing which was done, checked out by the Supreme Court in Ullapalli Nageshwar Rao case. The fourth bias is judicial obstinacy. What is that? Occurs when a decision maker unreasonably and persistently upholds their own decisions despite valid reasons for reconsideration. So this is obstinate. When judicial officer is obstinate that he will not change his decision. This is when this kind of bias occur. Hope you understood. Okay? This now upholds their own decision despite valid reasons for reconsideration. Even though there is valid things to reconsider the case, this judicial obstinacy can occur. And the case is A.U. Qureshi versus High Court of Gujarat. In A. Qureshi's case, we can see a judicial officer was dismissed from service after being found guilty in a disciplinary inquiry. Okay, judicial officer was found when a disciplinary committee inquiry was done. A judicial officer was found guilty, and the High Court recommended the appellant's dismissal based on suggestion of the disciplinary committee also. And the Supreme Court held that the judge who was part of the disciplinary committee should not have decided the matter on a judicial side. So the judge who was doing, he was also in the side of disciplinary committee. He should not have acted while deciding the case. So the kind of biases occurred when you are part of a committee and you are also deciding the case. There any kind of bias can occur, and the reconsideration of the matter will not take up. Okay, so the Supreme Court found out that it was improper for a member of the disciplinary committee to adjudicate on a challenge against the same dismissal order while acting in a purely judicial capacity. When you are there in a judicial capacity and when you are there in a disciplinary committee, you are not supposed to act as the same, and you are not liable for, you cannot do a proper thing there. Okay, so this was found out by the Supreme Court, and what Supreme Court set aside High Court order and remitted the matter for reconsideration, fresh reconsideration, and the principle that no judge should decide a dispute they have dealt with in any capacity other than a purely judicial one. So, when a judge is deciding a case, he should decide the case in pure judicial capacity and should not be beyond any. No judge should decide a dispute they have dealt with in any capacity other than a judicial one. This was the thing which was said by the Supreme Court in this case. And in conclusion, the rule against bias is a crucial principle of natural justice and fair administrative proceedings. It ensures that decision makers remain impartial and free from any personal, financial, or preconceived bias that could influence their judgment. So, while deciding the case, adjudicating authority, judges, administrative authority, they should be free from any kind of bias or preconceived notions so that the judgment is not influenced in any manner and they could enter the judgment in a proper way without any prejudice or any sort of bias. So this is rule against bias. We'll see you with the next video. Thank you.